Good afternoon, everyone. We're happy to have you here. Probably happier to have you here than you are to be here. We'll hear the cases in the order which they appear on the docket. For the appellants, please remember you can reserve time for rebuttal up to 5 minutes if you like, but you don't have to. And remember that we live stream these on the Supreme Court's YouTube channel. And once you say something, it goes out there into whatever the internet is. So always keep in mind that we should watch what we say sometimes. With that in mind, would you call the first case, please?
Re Knox G.
I'd like to reserve 3 minutes for rebuttal, please.
3 minutes, all right.
May it please the court, Nick Pernick out of the Nashville Bar. I represent the appellant father, Mr. Gordon. This is the 6th Indian Child Welfare Act case to come before this court. There are 5 unpublished decisions that have previously been heard. 3 of them deal with the existing Indian family doctrine and are really not applicable because that was abrogated by rule in 2016. The court in this case agreed that the Indian Child Welfare Act did in fact apply. And we're going to talk about that because there is no law on some of the sections of the Indian Child Welfare Act for Tennessee. Basically, this is a termination of parental rights case. The step-parents moved to petition to terminate the parental rights of the father. At the outset, the Indian tribe was not notified. Upon notice that the child was eligible for membership in the tribe, supposedly a letter was sent to the tribe and a letter received back from the tribe. But the Indian Child Welfare Act requires specific things to happen in 3 areas. 1 is notice and opportunity. 2 is active efforts. And 3 is the provision of an expert witness. I'm really going to start my argument with number 2 because that's the one that is clear and absolute error in this case. The Indian Child Welfare Act requires that active efforts be made to prevent the breakup of the family during the pendency of the litigation. Active efforts are more than creating a plan or entering an order. They're providing services to the person during that pendency of that litigation.
Counsel,
now,
are those requirements applicable in a case where it's a private party seeking termination rather than the state?
Yes, so that's been addressed. It's not on my brief, but RB versus CW, in re the adoption of TAW, it's a Washington Supreme Court case. Asked the question, does ICWA, or WICWA, their state version, apply to termination of parental rights in step-parent adoptions? And they said absolutely. The act says any party. It didn't limit it to the state. It said any party must provide active efforts during the pendency of the litigation.
Is what constitutes active efforts affected by the fact it's a private party? I mean, you're talking about services being provided, and does a step-parent have to provide services for
The step-parent would have to provide services, or in this case, you've got court intervention, so the court could. The court in this case said there were active efforts provided prior to the termination being filed, but he also said that the judge realized that Judge Smith, who had the case during the child custody proceedings, just laid out a plan and told the father to do it, which under the law does not constitute active efforts. Afterwards, it would have been the court saying, upon motion, and Mr. Gordon did motion the court, I want visitation. In fact, I believe twice. get me my visitation back, let me see my child, the court should have outlined a plan for him to be able to do that during the pendency.
In thinking about active efforts and on a state level basis, when we're thinking about efforts by, for example, DCS, we consider how cooperative the parents are and engaged they are. And in this case, father was not exactly the most cooperative in terms of following through on certain things, and continued to abuse alcohol, for example, when the trial court was taking steps. So does that affect the analysis in terms of whether active efforts were?
Well, as far as private parties and the judge, no. Maybe I'm not getting the question, but the requirement is more than you need alcohol and drug treatment. The requirement is, Mr. Gordon, by next Tuesday, you need to have an appointment with such and such, or attend this program, or do that. The statute clearly requires active efforts, which doesn't say just say you need this, but you have to do this, and it puts that onus, it seems, on the court. In the case of social services, when they're involved, it puts the onus on social services. But if social services aren't involved, then the petitioners still have to prove that active efforts were made. So it either need to be done through the court or privately. Hey, I've set you up with this kind of treatment or this thing.
I know you're sort of leading us into active efforts. I do want to talk about notice here a bit in terms of a notice and opportunity and your argument in that vein. Are you taking the position that harmless error analysis is completely inapplicable, or that it's not harmless here, or are you essentially arguing both?
Well, the statute clearly requires active efforts during the whole pendency of the litigation.
I'm thinking about the opportunity, the notice side of it here,
right,
rather than active effort. So with regard to notice here, at some point father became aware,
yeah.
And became aware of his statutory rights, and so. Is your position that there's just no basis for considering harmless error, or that this wasn't harmless error in this case in terms of notice, not active efforts, but notice?
I think there's no basis to consider it harmless error, because it's required. If it's a statutory requirement, you've got to do this. Just like the other side of things, notice may be a little bit more squishy, because there is a case in Tennessee where notice wasn't sent by the required method, but they said there was actual notice, so that became notice. As far as the active efforts go, there's no going back from it, from that period, and there was no testimony from 2021 when the case was filed through 2024 when the case was heard, that there weren't any efforts on anybody's part to help keep this Indian family together.
Counsel, with regard to the notice issue, in the amended answer to the amended petition for termination and adoption, under the first affirmative defense, it says, father raises the affirmative defense of jurisdiction and venue, as the minor child is Native American and registered as a member of the Choctaw Nation, Oklahoma, and the tribal court may be the appropriate venue pursuant to the Indian Child Welfare Act of 1978. Doesn't father clearly have notice at the time of the
second part to that initial notice? There's initial notice to the tribe, but there's also, in my brief, you'll see the notice. There's a list to the parents, to the person whose rights going to be terminated. Here are your rights underneath the Indian Child Welfare Act. That has to be said, registered mail return receipt requested to the parents. He never got notice of that. And you notice the court makes a big deal of, well, he requested a transfer later on the eve of the trial. Well, if he would have received notice day one, like it was required under the statute that said you have a right to request transfer to the tribe, that would have cleared that up.
Why doesn't the amended answer, though, indicate, assuming harmless error can apply, and I understand you're taking the position that it can't, but if it does apply, and there is an earlier decision of this court that applies harmless error in this setting, why isn't that rendered harmless by the answer? He's clearly aware of the statutory provision. It's in his answer. It's an affirmative defense that he's asserting. Why doesn't that render any notice? I'm not talking about active efforts here, but at least any notice aspect of this essentially harmless.
Well, I think rendered harmless is a consideration of all the circumstances. And I believe it's possible that the notice to the tribe could be rendered harmless if we believe that that letter that came back from the tribe understood that they had notice of this. But the notice to the parent of their rights is not harmless because he would have known he had the right to request that transfer on day one instead of waiting till the eve of trial.
Why doesn't his answer, though, communicate his awareness? I mean, his attorney filed an answer referencing the statute and his statutory right to transfer under the statute. And that seems
Right.
like awareness of the right to transfer.
Well, the other part of notice is that later on in the trial, when he did actually request a transfer, the judge makes light of it that he didn't bring it by motion, that he never set it for hearing. Well, the statute only requires that you notify the court, either orally or in writing, you want to transfer. And then the court has to do one, notify the tribe, never happened. Two, hold a hearing on the case, on the request for transfer, never happened. That is clear error, that failure to notice and failure to give the opportunity to be heard later on in the case. And that happened over and over and over again in this case. He requested more than once on that end.
Counsel, under 25 USC section 1911B, transfer proceedings, declination by a tribal court, there's language in that statutory provision that says, absent objection by either parent upon the petition of either parent or the Indian custodian or the Indian child's tribe. Does that effectively give a veto to the other parent so that mother can?
The statute seems to say that, but it says you've got to have the hearing to determine what the position and allow the views of all the parties to be heard.
But mother
But
could,
if it
mother
allows a
says
veto
no,
and the mother vetoed it,
then it
so
can't.
be it.
Okay.
However, we have to assume something else that's not in evidence there to say, okay, the mother would have vetoed it, and she wanted the case to be heard here and not by the tribe. So the question is, was the statute followed? Clearly not. But is it harmless or not? Some of them may be considered harmless, but some definitely are not. The second question I'll talk about briefly is opportunity for remand, failure to appoint an attorney. If you read the case file, Dad requested an attorney on the eve of the trial, before the trial, didn't file I think he did file a motion on that. The court questioned him, and if you read through the question, it turns out Dad listed as an asset Porsche Macan worth $85,000. Then under a debt, he had I owe Bank of America and I owe this country club. He was in jail at the time, and the court, instead of asking him the simple question of how much do you owe Bank of America on the Porsche Macan, decided that that was an asset that could be used to pay for legal services. That, and Mr. Gordon testified when he asked, how much money do you have? And he said, I have zero, nothing. And on the second day of trial, he filed another affidavit in indigency showing that he owed more than was worth on the Porsche Macan and was actually, didn't have any money. All he had was debt because he properly said, well, I don't have any income coming in while I'm in jail. And the court just basically dismissed that one also and said no attorney. So we ask that that would be a reason for remand on that.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Sarah Perkey for the appellees, Randy and Emily Fox. I'm going to address the appellant's arguments in the chronological order in which they were presented to the court, unless the court would like to address something else. First, addressing the ICWA notice requirements. Mr. Gordon contends that the trial court erred in failing to ensure that the Choctaw Nation of Oklahoma received notice of the termination proceedings by certified mail. It's well settled that the failure to send notice by certified mail is not error, where it is shown that the tribe had actual notice of the proceedings. Here, it's undisputed that the notice did in fact have, that the tribe did in fact have actual notice of these proceedings. The tribe, in fact, sent a responsive letter saying that although the minor child was, in fact, an Indian child under ICWA, it was not intending to formally intervene in these proceedings. Mr. Gordon's hyper-technical interpretation of the ICWA notice requirements places substance over form and is also, as the court noted, inconsistent with existing Tennessee law, specifically the In Re Contavious case. Moving on to the second issue raised by the appellee, he argues that there was not proof of active efforts at remedial services and rehabilitation beyond a reasonable doubt. Now, at trial, Mrs. Fox testified that her active efforts included cooperating and coordinating parenting time, supervisors facilitating FaceTime calls, telephone calls, traveling out of state to facilitate parenting time on holidays, continuing to facilitate the relationship between the minor child and Mr. Gordon's extended family after his parenting time was suspended.
Counsel, opposing counsel makes a point in his brief on behalf of his client that those efforts seem to have stopped at some point before these proceedings terminated. And I understand we went through two different defaults here in this case, but did those efforts, and we've got a federal statute coming into play in this case, were they required to continue throughout the life of the proceedings? Because at some point, mother does seem to have stopped engaging in active efforts in this case. And at some point, we have a trial court order, right, that cuts off all visitation too. So, and that's adding a wrinkle. But was she required under federal law to continue to maintain those efforts?
I think that the ICWA statute is really targeted at state agencies. I think that the whole purpose of the statute was to avoid breaking apart Indian families with state or public agencies involved, that had become an issue. I don't think that the ICWA statute, the federal mandate, actually is the same as the state statute requirements to terminate parental rights. In this case, I think that also what is important to know is that at some point, Mr. Gordon had a no contact order issued against him for harassment of Mrs. Fox. So that necessarily limited her ability to engage in active efforts. During this time, though, Your Honor, she continued to request that he undergo psychological evaluations, that he have anger management classes, and at some point, Your Honors, a litigant has to take responsibility. They have to be responsible for their own conduct and stop pointing their finger at everyone else and saying it's their problem. And that's exactly what the trial court held in its order. I'm sorry, go ahead.
In terms of the failure to visit ground in this case, for the relevant 4-month time period, father was under an order not that he couldn't visit with the children, right? I mean, or the child. There was no ability to visit. Why doesn't that negate, or essentially show that it wasn't willful? I mean, father has no legal opportunity to visit the child if he's under an order that says you can't visit the child. Doesn't that defeat that particular ground? Not all the grounds, but that ground.
Your Honor, I think that the timeline is really important to answer your question. On July of 2020, Mr. Gordon's parenting time was suspended for 90 days due to his alcohol abuse and mental health issues. Thereafter, on November of 2020, he was offered supervised parenting time, right? He didn't exercise any parenting time. He had 2 hours every week. He refused to exercise any of it. We then get to January of 2021, and at that point, he had a second suspension of his parenting time, again, for failure to maintain sobriety. He had engaged in witness tampering that was found by the trial court, and also had not undergone the mental health treatment that the court directed him to. There was no effort after January to lift that suspension. So at that point, it's really incumbent upon Mr. Gordon to file something with the court, to make the issue in front of the court, to lift that suspension. He did not do that. Your Honors, turning back towards the issues that were raised by the appellee, Mr. Gordon has also argued that the trial court erred in failing to provide the tribe notice of his motion to transfer jurisdiction under ICWA. Now, as an initial matter, Mr. Gordon failed to raise this issue before the trial court. Therefore, it is not properly before this court. Specifically, Mr. Gordon filed his request to transfer pro se, although he was represented by counsel. He did not docket this motion, nor did his counsel. As such, the motion was never properly before the trial court. However, even assuming that this issue had been properly before the court, Mr. Gordon himself provided copies of his motion to transfer to the tribe. Therefore, the tribe did have actual notice of the transfer request and still declined to intervene in the termination proceedings. And this is consistent with expert Randy Mann's testimony that the tribe had taken an intentional, what she calls, step back from opposition to the termination of Mr. Gordon's parental rights. Finally, the order of the trial court specifically finds that despite the motion never being docketed, that good cause, in fact, did exist in order to deny transfer, since the record in this case is very voluminous, and secondly, because every party, as well as the minor child, resided in the state of Tennessee rather than Oklahoma.
Counsel, in terms of the standard of proof in this case, you wouldn't disagree that there is a disagreement among state courts as to whether beyond a reasonable doubt applies just to the two listed federal requirements or whether it's also read in to the state termination grounds. I'm assuming you're not disagreeing with that point, that there's a divide out there on that.
I agree.
Why is the right way to go then, in your view, the direction of not reading in beyond a reasonable doubt as to the state termination grounds, but instead, I take it your understanding is that this is sort of a dual standard. Okay, so another requirement that you
Yes.
have, and why shouldn't beyond a reasonable doubt be read into the state termination grounds also?
I believe, Your Honor, if the federal government intended for there to be a higher burden of proof beyond a reasonable doubt to all the state requirements to terminate parental rights for an Indian child, it would have explicitly said so in the statute. It's not in the statute. This issue has never been addressed directly by this court or any Tennessee court. However, the majority of other states do apply a dual standard of proof. We submit that this is consistent with the intention of the statute, as well as the legislative intent. The purpose of the enactment of ICWA was to avoid the unwarranted removal of Indian children from an intact Indian family by public or private agencies due to cultural insensitivities. The provisions of ICWA are largely aimed at ensuring that efforts are made to make sure that the tribe is notified and that they are permitted to be involved if they want to be in the proceedings, as well as ensuring that remedial measures are made available to an Indian parent in order to try to keep that family together. This case is very different than that. We are not involved with a public or private agency. We are dealing with a biological parent and also a step parent. I think that the dual approach that has been adopted by the majority of other states is the most practical approach, wherein the clear and convincing standard of proof is established for state law requirements to terminate, and then we use the higher standard of proof, the beyond a reasonable doubt, for the federal requirements under ICWA. I believe a final issue that the appellee raised during his argument was that the court incorrectly found that Mr. Gordon was not indigent and therefore should have been appointed representation. As the court is well aware, a litigant has to be indigent in order to be appointed counsel in a termination proceeding. In this case, the court correctly followed the procedures set forth in Tennessee Supreme Court Rule 13. The court provided Mr. Gordon with an affidavit of indigency when he requested it on the first day of trial. He completed that under oath. He affirmatively represented to the court that his income was $250,000 a year and that he owned a Porsche that was valued at $85,000. After weighing all of the applicable factors, the court correctly found that Mr. Gordon did in fact own assets, i.e. a Porsche, which could be sold so that he could hire an attorney. Now, Your Honors, I also think it is very important for the court to note that Mr. Gordon retained 3 different attorneys during the pendency of this matter. He fired the last one on the very eve of trial, and this was indicative to the court that Mr. Gordon's most recent efforts to say that he was indigent was likely another delay tactic. As the court is probably aware, this matter was pending for almost 3 years. As such, our position as the trial court correctly found that Mr. Gordon was not indigent and therefore not entitled to appointed representation. Now,
Counsel, with regard to the determinations as to indigency, are there essentially credibility judgments that are being made that are intertwined with that in terms of the trial judge? And the trial judge plainly didn't find father credible. How does that play into the indigency determination and what sort of the appropriate review for this court to take is with regard to that matter?
I think that the basis of the indigency affidavit, as well as the questioning that was done, is fact-intensive. And it calls into credibility whether or not the court actually believes the things that Mr. Gordon was representing to the court. So I do think that that is clear. And also from the record, it is very clear. I think the court actually found that he had, quote, 0 credibility and that his conduct in delaying these proceedings and failure to participate in the proceedings was in fact willful. So I do think that that's a consideration that the court should consider in deciding the indigency issue.
Let me ask you a question about
Yes, Your Honor.
that. The affidavit was submitted to the court. Court reviewed the affidavit. Was a hearing then conducted?
The next day, the following day, on the second day, the court did engage in some discussion with Mr. Gordon.
I think we may be playing on words here.
Okay.
Was a hearing held? Was testimony taken regarding his ability, financial ability?
Yes, Your Honor. I believe that that is in the record. On the second day of trial, he did ask him questions.
Okay. And
Now,
it was under oath?
I assume it was under. I was not the trial attorney,
Okay.
so I can't affirmatively represent it if an oath was administered. In my experience in Fourth Circuit, when litigants enter the courtroom, they are placed under oath, and the court advises them that that oath is going to continue throughout the proceedings. However, I was not present on the day of trial, Your Honor.
Okay. I know in my trial experience that normally the affidavit submitted, if someone's dissatisfied with the decision of the trial court, they can ask for an evidentiary hearing, present any proof that they want to in support of their position. And I'm just trying to ascertain if that procedure was followed here.
I'm not sure if that was followed, so I don't want to make a representation to the court as to that. I apologize. The sole issue that was raised by the appellees on appeal, Your Honors, is a request for fees. The record is replete, Your Honor, with evidence that presents that this appeal was not taken in good faith. The arguments that Mr. Gordon raised on appeal were in large part waived. They are also legally baseless and lacking in any factual support. Despite this, the appellees incurred substantial costs in having to defend this appeal, not for themselves, Your Honor. They did this for this child that doesn't have financial resources to protect this child. As such, the appellees respectfully submit that in the event that they are successful on appeal, that they be awarded their fees. Thank you, Your Honors.
As to the issue of attorney's fees on appeal, I don't see where there's any statutory authority for attorney's fees on appeal. In child custody cases, yes, but this is a termination of parental rights case, and I've never seen that.
Counsel, let me ask you a quick question here. Same question I asked opposing counsel. We've got this split among states with regard to the standard, and it's obviously critical in this case. If it is beyond a reasonable doubt, the findings are not under that standard with regard to...
There is a split. The majority of states either A, use the dual level of proof, or B, they have codified in their statute that in ICWA cases, then it's going to be beyond a reasonable doubt.
Same question as to opposing counsel. And why, except from your side, why is the correct answer in terms of statutory interpretation that it's beyond a reasonable doubt as to all of the grounds for termination?
Because the federal statutes, the policy there is that states have a history of breaking Indian families up just to break Indian families up and put them into non-Indian homes, and that we need to protect these Indian families. And that's the proof beyond a reasonable doubt should go towards the state level as well as the federal level, because the goal there is to prevent that breakup, which state governments, state social services, and other folks have tried to perpetuate over the years, which is the basic reason why the Indian Child Welfare Act was enacted. So that's why it should apply to both the federal grounds and to the state grounds in case of children that are Indian children at this time. I'd ask to respond to one more thing. As appellee stated, there was no active efforts from the time this litigation started until it ended. The statute regarding active efforts is titled Section 1912, Pending Court Proceedings, and then it requires active efforts. That's exactly what this is. It doesn't matter the time period beforehand, it matters the time period of the pending court proceedings. Case law supports this. In the case of Sandy V versus State Department of Health and Human Services, this is an Alaska case in 2009, the Supreme Court said, the trial court properly considered all of OCS's efforts from the time that it first became involved with the family in September 2005 until the trial on termination of Sandy and Leo's parental rights began in April 2008. That's what the statute says, and that should be the interpretation, that from the time the petition is filed until the time we have that first day of trial, there need to be active efforts. As far as Mr. Gordon's issues, I apologize.
Thank you very much. Thank you both. Would you call the next case, please?
SAP America Inc. versus David Garagano, Commissioner of Revenue, State of Tennessee.